All right. Welcome to the Credit and Collection News podcast. I'm Steve Ruderman. I'm the host of Credit and Collection News. And we are lucky enough today to have three experts from the industry who are going to talk about the Chevron Doctrine that just came out last week. And who we have on today is Stefanie Jackman, who's a partner at Troutman Pepper. Stefanie devotes her practice to assisting the financial services institutions that are facing state and federal government investigations, examinations, and counseling them on the complex compliance issues. She regularly advises her clients on issues arising from everything from UDAP to the FDCPA, FCRA, TCPA, FTA, SCRA, and TILA. If you know all those letters, then you know what's going on in the industry, because that's what this is all about. It's all talking about letters. Our second person is Joann Needleman, who's a member of Clark Hill's financial attorney firm, and she heads their financial services regulatory and compliance practice and advising banks and financial institutions. She prepares and represents the same financial institutions also on state and federal supervisory examinations. And she's definitely an expert on the CFPB, the FTC, OCC. Again, here's all those letters. And she's a former member of the Consumer Financial Protection Bureau, the CFPB's Consumer Advisory Board. And our final member is Richard Horns, and he's a former senior counsel and special advisor in the CFPB's Office of Regulation, and he's a former senior attorney at the FDIC. So again, lots of those letters talk about. He's currently co-managing partner at Garris Horn, and at the CFPB, Richard led the final rulemaking for the integrated disclosures under the Truth in Lending Act and the Real Estate Settlement Procedures Act, including TILA and RESPA. The integrated disclosure rule known as TRID. He also led the CFP design and the integrated disclosures, as well as the qualitative and quantitative consumer testing of the disclosures. He's a key architect of TRID rulemaking, and he's one of the foremost experts on rule. In private practice and government, Richard has worked in consumer compliance and risk management, supervisory matters, and enforcement actions. Like I said, we have three ultimate experts that are, here today to talk about what happened last week. What did the Supreme Court do to not only our industry but every industry with the Chevron Doctrine? And with that, I'm going to turn this over to the experts. So I'm not sure if someone wants to jump in on that knife and say, I'll go first, or I'm just going to randomly pick someone to do it. But Joann, you're smiling, so hey, why not? Why don't I throw you under the bus first?
Well, thank you. Thank you. I really
we'll
appreciate
go ahead and get started.
Steve, thanks so much for bringing us together, and it's always great to see Stefanie and Richard. Huge fan. I read all your stuff, and I love what you're doing, and it's really nice to be on a podcast with you. So I'm very honored.
Thank you so much. I appreciate it.
Very honored. So I think it's not. I think you have to look at what the Supreme Court did this year to really they kind of built on a lot of things to have to really attack. I would say the state of administrative law. It's kind of been very much out of whack for the past decade. And I would say with a combination of 3 and 4 decisions really has kind of reined it in. Now, whether that's a good thing or bad thing, I think we're all going to talk about. But what I think the Supreme Court did was really bring a sea change in how the executive branch, who really, where all these agencies sit, how they're going to fit in with this whole, I will say, separation of powers. What's going to be their role? So I think it started out with the West Virginia versus EPA case, where the Supreme Court, and they have in a couple other cases, looked at the major questions doctrine, really have questioned how administrative agencies implement rules, how they exercise their authority, and whether these rules are appropriate. Then we went into the day before Chevron. We had the Jarksy case, which was reining in on administrative law judges. And if an agency is going to bring actions against entities, in this case, it was the SEC, should those entities, when there's going to be civil monetary penalties and when there's issues of fraud, should they have the benefit of being tried by a jury rather than really the agency's own judges? And we can get into how that whole process works. And we've seen that. And I'm sure, Richard, you've seen that in the PHH case. That was a
Right.
grotesque example of how to use an administrative law judge and that process. Then we had Chevron, which did away with 40 years of doctrine in which courts would give deference to how agencies interpret law and really took away how agencies can interpret the law and whether they should be interpreting the law. That really should go to the courts. And then finally, there was I keep calling it Cornerstone, it's Corner Post case. And my apologies to our dear friends at Cornerstone Licensing, who we all love very much, but I keep changing it. And this was about, how, the statute of limitations when it comes to challenging rules, and that kind of opened the door. So, Steve, you could probably have about 6 webinars on all the cases that have come out in this past year about, how we need to look at agencies and what are going to be the role of agencies in this process. But that's how I look at it. I think Chevron, I think everybody knew Chevron was coming. The court said in its opinion that they haven't used it since 2016. So I think you have to look at Chevron for what it is, and I think it's important, but you have to look at the entire body of work that the Supreme Court did this year to see that administrative law is very different and will be moving forward from the end of this year through 2025 and maybe through a next administration.
Yeah, I think Joann is absolutely right that there were a lot of cases this term and in prior terms. I think you're right to mention the major question Jackman case, West Virginia versus EPA, but this term especially, there are a lot of administrative law decisions that can change the way courts deal with the administrative state. Loper, Bright, and Relentless are a major piece of that because this is how courts will interpret the statutes that these agencies are tasked with interpreting and administering and creating laws to implement. And for decades, Chevron has been the doctrine that says when courts decide what the statute says on its own or when it defers to the agency's interpretation. And now, after decades of thousands and thousands of cases, especially in the lower courts, as Joann mentioned, so the Supreme Court hasn't cited Chevron in many years, but the lower courts use it all the time, and it's kind of the way lower courts punt to an agency's interpretation in some respects, because sometimes lower courts are very busy. They don't really understand the subject matter as well as the agency does, and so they say, well, the statute's ambiguous. We'll just kick it back to the agency and defer to the agency's interpretation. But now what the Supreme Court has said is that after decades of lower courts being able to do that and cite Chevron, that now lower courts are not allowed to do that, that they have to interpret these statutes. If the agencies are coming up with an interpretation that is reasonable, it doesn't matter. The court still has to interpret the statute on its own and find out what it thinks is the best interpretation of the law. We should probably back up and before I give that perspective on what the future might be. Maybe it's worth backing up and saying what Chevron is this 2-step test where courts would, for a statute that an agency was interpreting, first at step 1 decide whether using all the tools of statutory construction and interpretation that it has, decide whether the statute was actually clear or whether it was ambiguous. And if the statute's clear, then the court would just decide that that the statute is clear and it says what it says. But if the court decides that the statute is ambiguous, that there's some ambiguity in the language in the statute, in a statutory term or phrase, or even if the statute's silent, courts would decide that that counted as statutory ambiguity. The court would defer to an agency's interpretation if it found that the agency's interpretation was reasonable. And that's what I mean by punting to the agencies. And lower courts cited Chevron all the time. And now lower courts, all the courts really can't do that anymore, appellate courts also. So I think that this could have a huge impact. The one thing that it's worth reminding listeners is that the Supreme Court, and I think a criticism of getting rid of Chevron from many scholars and lawyers and people on the policy side said that, well, Chevron allows policymaking to be done at the agency rather than at the courts. When you get to a point where the statute's ambiguous, it was essentially Congress saying we want it was like this implicit delegation to the agency. We want the agency to interpret all of these ambiguous terms and phrases and silence. And so a lot of folks who wanted Chevron, who supported Chevron, said this is a way for policymaking to remain at the agencies. And the court said, well, no, that's actually an interpretive function. That's a function of the courts, is to decide what the law means. And so there's this kind of distinction between the two, and it's hard to decide, where policymaking begins and legal interpretation ends. And so what the Supreme Court decided was where that line was drawn, and essentially, interpreting the law is the judiciary's function. But what the court said is you could still take into account the agency's perspective on the law. It's, what it thinks the law says. That can still get weight. And what the Supreme Court did was kind of harken back to a different deference standard called Skidmore. And this deference standard under Skidmore says that agencies can give weight, courts can give weight to agency interpretations of statutes. And this applied to informal agency interpretations because Chevron applied to formal rulemakings and formal interpretations. Skidmore applied to informal interpretations, which would get weight. And essentially the Supreme Court said, look, courts, you can still essentially apply Skidmore and give weight to agency interpretations that you think, use the agency's expertise. And there's all sorts of standards and factors that apply to Skidmore deference. It isn't deference, though. It's weight. Like I said, even at the oral arguments for Loper, Bright, and Relentless, one of the justices said, what is Skidmore? Skidmore is nothing, because it's really just if the agency's interpretation persuades the court will use that interpretation. But there's still that ability for the court to look at, the agency's expertise and what it thinks the correct policy is, and all that, what the agency does to work up its interpretation. And I'll stop there because I know I've talked for a long time.
What's interesting? Well, first, I echo Joann. It's wonderful to be on here. Thank you for having me. It's great to see both of you. I think you both raised amazing, valid points. Couldn't agree more. And thank you for doing the job, Richard, of saying what Chevron was and wasn't. Because I don't know about others, but I've been going back and refreshing on Skidmore, our Chevron, all the differences. Looking towards the future, though, and in reading the opinion, one of the things that jumped out at me is under the, because the majority looks at this as a case that's about resetting the appropriate balance of power from a checks and balances type of perspective, right? And we really saw that in Justice Gorsuch's concurring opinion, where, he went back to Old English law and brought it forward. But one of the points where the dissent really, I think, rubs against the majority is one of the jobs of the judiciary is to have consistency, right? And the majority of opinion says this isn't leading to consistency, and here's our reasons why. And the dissenters say it has led to consistency, and getting rid of it will reduce consistency, and here's our reasons why. I kind of feel like right now they cancel each other out on that point. And it caused me to look towards the future and go, all right, I agree that one of the basic things I was taught way back in US history and grade school is we have checks and balances. I'm only a bill, schoolhouse rock, right? The legal branch is kind of the brakes. They're supposed to ensure some consistency over time. Stare decisis, which was talked about a lot in the opinion. Will this ultimately lead to consistency? And I've been trying to think about that. And I think, and I'm sure that Steve will ask us some questions about this later on in the podcast. I think in the immediate term, no, we're going to have lots of disruption, right? And I think the dissent does raise a good point that things that had not been challenged in the past could be challenged now. I've had clients, I'm sure you both have as well, saying could plaintiffs, consumer advocates thinking through the CFPB lens, challenge Reg F or challenge Reg X or things like, yes, I mean, that absolutely could happen. This isn't a one-way street for sure. It's not just the industry. But over time, I also think about some of the cases we've seen, again, in the Reg F context, of some judges starting to say, I'm not going to do Chevron. I'm instead going to say that the validation notice you used before Reg F is still valid and binding, and you can use that, right? And I feel like over time, we may get some more judicial continuity, and we are in a period of massive swings in the administrative side and have been for some time, several administrations back. This isn't a new phenomenon. So to me, whether I agree, with the court's reasoning or not, or whatever, because the Supreme Court's going to say what it's going to say, I'm not surprised. I don't think anybody else is surprised, because I see the court in some ways exercising its braking function to say we've got a lot of turmoil going on in the consumer financial services world and elsewhere, with complete changes in the administrative positions, uncertainty. So we want courts to come in and be weighing in on that and building maybe a baseline of case law for the future to stop that swing. But that's just something that's been playing in my mind the last week or so.
I think that you have analyzed Judge Roberts' thinking in this perfectly. That's, I think, exactly where I think he was coming from in this decision. But Stefanie, you know better than me in the last decade how, and Richard, Stefanie and I have been in the debt collection Reg F space for so long, and you've been more in the TILA Reg Z space. But right. Chevron was not used, has not been used in the FDCPA world and in with the CFPB that much. I think they kind of knew it in the back of their head, but courts didn't really use Chevron and anything. I couldn't find any, maybe one or two. I think they did in mortgage law for a whole different reason. And I agree with you, Stefanie. I mean, I look at the majority's opinion, and I think that's exactly, if you read between the lines, that's exactly where Roberts is coming from. But I think back to the last 15, 20 years, dare I date myself. And, when I used to litigate cases, not to the level that Stefanie did. But the biggest problem that we had in the FDCPA world was the differing of opinions about what the FDCPA was. Now, granted, we did not have Reg F then. Okay, but now we do. My concern with Chevron, both in the FDCPA world and any in financial services world, is going to be this now differing of opinions. Courts are divided. They are. And you know that going in. And I think it's a little, dare I say, naive of the Chief Justice of the United States to think that courts are going to, they come in with their preconceived biases. They just do. And you would hope that when you come to court, they put those biases aside and they look in the facts and law and they call the balls and strikes. But even in baseball, and I'm a huge baseball fan, they're talking about robots now because the umpires can't call balls and strikes. And there's good umpires and bad umpires. And so I agree with you, Stefanie. I hope long-term this evens out. But I worry in the next several years that you're just going to have, and I've seen it. I'm in the Eastern District of Pennsylvania. Judges on the same floor, hearing the same set of facts. One says yes, one says no. And I think we're going to have that. And is that what we really, really want in financial services, which I think having consistency in the law is so important. So, I agree in I hope the long-term effect is this, but I am very, very skeptical in the short term.
Yeah, it's a great point. It's almost like, Justice Roberts is picking the poison, right? You can have temporal uncertainty where courts defer to the agency, and you have potential wild, swings in policy every 4 or 8 years. So there could be uncertainty just because the agency's policymakers have changed, or you could have uncertainty across the country because different courts are coming up with different interpretations, from looking at statutes through their own lenses, like you were saying, Joann, which is a great point. I think the Supreme Court just picked its poison and said, look, that basically the role of the courts is to decide what the law says, and that's the way our system works, and that's how things should work out. When Chevron was in place, you still had that kind of difference between the courts in when courts under step 1 of Chevron would decide whether a statute was clear or ambiguous. So there was still some uncertainty under Chevron that was there, which was cited by the court as a reason why stare decisis shouldn't be a reason to keep Chevron in place. So it's, you're just picking your uncertainty to some extent. And you're right. Chevron was used more in the mortgage space, or in other products that are governed by Reg Z, credit products. So there's a lot more experience with that kind of uncertainty for those credit products. But lately, I think, like we talked about, the Supreme Court hasn't cited Chevron. I think you're right, Stefanie. Courts have been trying to almost not cite Chevron because the writing has been on the wall for so long. Just from the way the current Supreme Court justices' writings have been on Chevron, and especially after oral arguments, I think most people thought that Chevron was going to meet its demise in this opinion, and that's turned out to be the case. So there's been this kind of hesitance by the courts to cite Chevron. That still doesn't do away with the fact that, like you said, Joann, courts, judges bring their own lenses into their decisions, the way they see the statute. So there's still going to be some level of uncertainty across the country.
Well, what if you're looking at in the wording that they used, interpretation of ambiguous statutes? How do you even interpret that? Because when you say interpret of ambiguous statutes, I mean, you best have a good lawyer like the three of you representing yourself, because if a ruling or a judgment goes against you, I would think the first thing you're going to jump into is, well, it's pretty ambiguous. And that's going to be your first line of defense, to come back and say, well, let's take a look at Chevron, and we think this is ambiguous. But I would think every case suddenly, there's nothing that's so clear cut you can do that. And particularly if you start looking at the way that artificial intelligence is now coming into the financial services arena, which is nothing but ambiguous, because there's no laws right now that says, okay, here is what the ruling is on artificial intelligence. Every particular agency, federal agency, state agency, is looking at that saying, well, this is the way that we interpret it. How do you even start to look at something like that?
Yeah, that's a great question. I think it often comes from the other side, actually, especially with an aggressive CFPB. Often someone who's defending themselves against a CFPB or trying to challenge a rule will say, look, the statute's clear. CFPB can't do this. One example is a case that I'm involved in. I represent Chevron Financial, which was sued by the CFPB for redlining, fair lending, alleged violations of ECOA. And the statutory authority in ECOA, essentially the general statutory prohibition in ECOA says creditors creditors can't discriminate against applicants, and applicants is defined in the statute as someone who's actually applied for credit. But what the CFPB is trying to do is cite its regulation, which goes further than applicants and says creditors can't discourage quote unquote prospective applicants. Those are, and that term is not defined, but the way the CFPB is using it in the case is essentially anybody in the general public. And so our argument in that case was that essentially the CFPB is going outside the boundaries of the statute in its Regulation B. And the statute's clear that the statute's boundary is applicants, people who've actually applied for credit, and CFPB can't go beyond that boundary. And so oftentimes, arguments are going to be that the CFPB or another aggressive agency is trying to go beyond what Congress has set as its authority, as its limits on its authority. And our argument actually won in district court. This is the first time a redlining lawsuit by the government was actually litigated in court, and we won. And the court actually cited Chevron, because we framed our defense as a Chevron step one, argument that the statute's clear, so you don't get to, step two, and you don't defer to the CFPB's interpretation and their rule. And the court agreed with us and said the statute's clear, the limit is applicants, and so we're not deferring to Reg B, and there's no claim here. Now the CFPB's appealed that to the Seventh Circuit. We're still awaiting a decision in that. I think we'll see a decision soon after Loper and Relentless have come out and overturned Chevron. But that's the way I think that these challenges are going to go now, because there is no second step. There is no chance for deferring to the CFPB or another aggressive agency's interpretation. So a lot of the arguments are going to be, look, the statute's clear, CFPB can't do this, it doesn't have the authority. I think another way litigants are going to challenge agency actions is that the agency's relying only on its general rulemaking authority for its rule that it's relying on in an enforcement action, or if someone's just challenging that rule. General rulemaking authority is something that says something to the effect of agency has the authority to promulgate rules to further the purpose of the statute. And you see it, especially in aggressive agencies, that they use this general rulemaking authority all the time to try and do something new, something that the statute doesn't say that Congress wants it to do, but it just goes off and essentially creates new law based on this further the purpose of the statute language. And I think that that's going to be another avenue of attack by challengers to agency actions, either rules or enforcement actions. That issue came up in our Townstone cases as well, but it's also come up, in other recent cases as well. So I think that that's going to be an area of litigation in the future.
I couldn't agree more, Richard. I think that'll be where a lot of people start in challenging it. So going to Joann's point, I'll jump on Joann also being pushing back, I'll say, not critical, pushing back on our Chief Justice. And your point that there may be a little bit of naivete in some of the approaches or positions, and this is another place where trying to take a step back and look longer term, which I'm doing for my own reasons, right? Instead of trying to be in the waves of every day, it seems lately. If you're trying, Chief Justice Roberts has been on record multiple times over of saying it is not the court's job to step in for Congress and legislate, right? So I also think he's saying to Congress, and I saw in the opinion where they talked about how easy it is for Congress to have amended the APA or to do other things. We know right now we have a dysfunctional Congress. I don't think I'm giving any secrets away in saying that. And maybe that's good, maybe that's bad, right? I mean, there's difference of opinion there too. Some people think that our democracy is functioning best when nobody can get anything done because there's no consensus. That may be. But his point is, if you want courts to understand what your intention was, Congress, be express about it, right? And again, this may be naive, right? And it may not happen. But his point is, there is a way through another branch that I, as Chief Justice, do not think I should step on. Like that has been him for a long, long time, and others. It is for Congress to be more specific in what I'm delegating, the scope of what I'm delegating, who I want deciding it, right? And here's my legislative reasoning for things. Think about the FDCPA, because Joann's point, we've lived with that statute a lot. It was passed in the 1970s, before email and text, certainly AI and lots of technologies that are common. And one of the things that was good about Reg F was it was an announcement by the regulator that was charged with interpreting that statute as saying, yes, this should authorize email and text, right? So you didn't have to argue that communications should be broad enough to evolve, blah, 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 blah. You could point and say, the CFPB has said, they have clearly said these are allowable in the collections context to quell those types of arguments and others. If Congress wanted to make that clear, they could. We want this to grow and incorporate new technologies or changes, or we don't. And a later Congress that feels differently can change it. Again, that's how it's supposed to work. If I think back to It's Only a Bill in Schoolhouse Rock, whether that will work is a whole different ball of wax. And I don't think it has been working for a long time. So I don't know where we go, but I'm hopeful that this is something that at some point when our Congress members get back to the business of running our country instead of whatever they've been doing for the last decade or two, this is something that they're thoughtful about.
Steve, to answer your point, and I agree with both of your comments, there is something I think that deals with the ambiguity, and that's called the APA, the Administrative Procedures Act. And I think that my experience, and Richard, you probably know better than anybody else, but you work within the bounds of the APA when you develop, I'm going to call it TRID, and I know Richard Cordray hated when people called it TRID, hated that term,
Yeah.
hated it. But
It's
I'm
a
going to
one-syllable term, so it's stuck. It's very easy.
He's stuck, and he's like, it's not TRID. Anyway, but there is an APA. And I think in the one area where I think that the CFPB respected the APA was in TRID and was in the changes to Reg Z and Reg X. Because you remember, how many times did those rules get amended? There was even an amendment for FDCPA because when loss mitigation, somebody said, don't call me anymore. There was a cease and desist, but they had to call them in loss mitigation. They were kind of stuck in a quagmire. And he addressed it. And so I think that the APA is the, right now, ability to get, it's the law that's out there. It gives the agency an opportunity to develop these rules in a way where they can be consistent. But unfortunately, and Richard, you know this, and Stefanie's lived through this like I have, we have had the Bureau in the past decade under certain directors kind of give short shrift to the APA. They went through the motion of SBREFA, but did they really do it? Did they look at cost benefit analysis, but did they really do it? And I think that if, agencies have this law that allows them to write rules, allows them to get comment, but the point is that they really have to, rather than just go off on a tangent, they have to use the APA. And my prediction, I think, and again, I think this is completely Pollyanna, is that, hopefully agencies will be more, not that they don't meet with stakeholders, but they will value some stakeholder positions. They will come to the middle of how they do the regulations so that we can have consistency, because challenging for them is going to be equally as difficult as it will be for industry. And that goes nowhere.
Does this open the floodgates? Does it change the floodgates? Does suddenly there's more litigation? There's less litigation? Because you can look at it from different standpoints. I mean, does it give more clarity? Does it not give more clarity? And so what are your thoughts along those lines with this new direction. And of course, we're smack in the middle in, just call it election season now, because we no longer have election day, we have election season. And it seems to start literally the day after an election ends, because if we don't like this, well, now we're going to focus on changing that. And if you have a consistent change in government, how does that affect it? And like I said, we're usually, these podcasts are an hour, and what I just threw out there is probably will take days to decipher. But again, let's just kind of focus on that for a second. And like I said, does this clarify things, or does it make it more muddied in the direction that we're going into?
I think it definitely sparks more litigation right now. And like I was saying before, part of me in trying to read between the lines is I feel like the majority, it's that they may be making a call to Congress saying, you need to take this back over. And it's going to cause some disruption, economic disruption, other disruption, uncertainty, as courts, to your point, Joann, grapple with this and reach different opinions. So fix it. Whether they'll do that is a whole different story. But that's what's going to happen. I had somebody ask me the other day, what do I actually, one of my partners says, has anybody, it was within about an hour of Chevron coming down, has anybody analyzed what this means for existing FCC rulemakings in the TCPA context? No, because the opinion came down an hour ago, but I've been thinking about it since. And if I'm, thinking about some of the litigation I'm seeing there, where people are trying to assert that consent wasn't, fully informed. It was in boilerplate. I didn't know about it, to try to undermine the validity of the consent where they can't prove a revocation. I think it's a 2003 FCC rulemaking that said when a consumer applies for a financial product, you can assume when they provide you that number that you can contact them about that account at that number.
Okay.
That's kind of a cornerstone, and has been for a really long time, of how a lot of companies approach TCPA compliance out of the gate. It doesn't have to be the only one, but if I'm a plaintiff trying to bring a claim, I'm going to argue you don't have to defer. Now, whether I'll be able to make compelling arguments to a court that doesn't make sense, that's apples and oranges. And I actually think that would be a difficult thing to do. But to Joann's earlier point, it could be done. And with the right judge, judges bring they're supposed to do their best as judges to be impartial arbiters of the law, but they're still humans, and you're going to have uncertainty as it works its way up to courts of appeal. Maybe that uncertainty goes away. Maybe there's more uniformity. Courts are going to be working hard because there's going to be more challenges until Congress changes it. And it's an interesting play by the Supreme Court, because they control their docket and how much they're going to hear in a way that the lower courts don't have that luxury, and may not have the resources to keep up with, at least, Joann, to your point, the next few years of litigation.
I think what it means, certainly also going forward, as I mentioned in my last comments, the last 6 months, the CFPB has put out a lot of interpretive rules. So I can't see them happening anytime soon. But again, going back to my point during, Reg Z, Reg F, and all the amendments that happened there, is there, can there be opportunity through many agencies? And I've seen negotiated rulemaking. I know there's been a lot on the environmental side. There needs to be, and whether agencies are going to be willing to do it, because again, agencies are political, whether they would want to have some sort of, we are thinking about an interpretive rule. Let's bring in the stakeholders and think about what that interpretive rule may mean, and can we get some consistency? Because again, I think it's going to be, if we go down this path of litigation, it is going to be just as difficult for the agency as it will be for the industry. Now, resource-wise, agencies sit in a much better position that way. For industry folks, whether they're going to challenge is going to be a financial decision, for sure, unless you're, some of the major banks. But for anybody else, especially non-banks. That's the cost benefit analysis that's going through their head at the moment. But I believe there could be a lot of litigation. I also believe there could be litigation avoidance if there is more interaction with the agencies within the industries that they regulate, and coming to that middle ground to avoid that. Again, I think that's super Pollyanna, because to Stefanie's point, Congress is going to have to amend a lot of laws, because even TILA and RESPA are 35 years old. FCRA is 30, 40 years old. TCPA was in 92, but yeah, they never thought of cell phones. So that's an archaic law to begin with. So, all these laws can't possibly keep up with the times, and they can't possibly have amendments and changes unless you have a pandemic, which magically the FCRA got amended within 3 days. But until that happens again, and I hope it never does, the opportunity for some more negotiated rulemaking and having industry and stakeholders and advocates or whoever on either side of an issue, maybe that's a wake-up call for them to start doing that. But I think that's, again, a little bit of wishful thinking.
Yeah, those are great points. And I'll just add that I think that for agencies that are trying to create new rules with new requirements that are aggressive, like we've seen from the CFPB the past couple of years, I think that they'll be less likely to do that in the future, because without being able to have Chevron deference in your back pocket, there's going to be a greater frequency of challenges to rules, and also a greater likelihood that those challenges will be successful. Now, add to that the Corner Post opinion or Cornerstone. Joann said, if you're a Sixers fan, you like Cornerstone better, I guess. But I think there'll be more likely to be challenges to rules. Also, when the agencies try and use a rule to enforce against somebody in the industry, that also creates a greater likelihood of a challenge. So I think there'll be perhaps less aggressive enforcement against companies that may be more likely. I know there's a lot of maybes. I sound very lawyerly, but aggressive enforcement against companies that may be more likely to challenge those enforcement actions. So what we might see is more regulation by settlement. So not necessarily negotiated rulemaking, but also enforcement actions against companies that are more likely to settle, that have aggressive legal interpretations or interpretations that push the envelope. And as we know, the CFPB and other agencies view their settlements as some kind of precedent, almost like a common law. We even had former Director Cordray on the Hill when he was director of CFPB, saying that the industry has to follow the agency's consent orders, and if they don't, that he views that as compliance malpractice. So the agencies expect the industry to follow their consent orders, and so I think the agency, to avoid legal challenges, will move more to regulation by enforcement or settlement. Does that benefit the industry? I don't think so. In one respect, industry likes certainty, regulatory certainty. And formal rules do have the benefit of having the force of law and giving the industry certainty that they're compliant. And the industry likes that certainty. And so, having question marks surrounding the agency's rules and fewer formal rulemakings in the future could be a detriment to industry. On the other hand, for entities that are facing enforcement, with aggressive legal theories, I think that this could be beneficial. But from a rulemaking standpoint, I think we're going to see a decrease in the amount of rulemakings going forward.
That's a lot of information to take in for an hour, to just kind of go through the process, because it's there. And like I said, we are smack in the middle of an election that, depending on how things go, and we're in July, and the election is not until officially November. So in the next 4 months, I think we're going to see a whole bunch of things, and you're going to see if we have a change in the White House, if we have a change in the Senate, if Congress stays the same, a direction one way. If you see it go a different way, where the Senate and the White House stay blue, and Congress goes blue, you're going to see it go a different direction, and which way the regulatory goes. And now we've seen that the states are not shy either way. If you're a red state, you're going to stand up against all the regulatory that's coming from a blue administration, and vice versa. So no matter what happens, we see this all as a just how it continues to go forward. I really don't know. I think, Joann, you said it great when you said they have to, maybe they're gonna start to get things done, or not, because we seem to be in this consistent state of not getting things done. And even if we have one party in charge of everything, will it all get done? And the answer is I really don't know, because lately it just seems like nothing gets done, and it gets done except, like Joann mentioned, if it's a pandemic and we get 3 days of, okay, we will change this, and we'll change it now. But the reality is that just doesn't seem to be a reality. And if all of a sudden you have a complete change of administration, does that mean that the agencies suddenly have different people in charge? And different people in charge means the rules go a different way. I've already read some focus on the CFPB. If everything goes red, one of the first things that's going to happen is there will probably be a change of leadership at the CFPB. And what does that mean if suddenly you've got a completely change of direction? And I know, Alan, you work there, and if you have a complete change, does that mean that they changed direction? When you went from Cordray to Kathy, what changed, what didn't change? Was there certain functions that still had to happen the way they had to happen because that was the interpretive rule of the CFPB?
Good question. What happens when you have a change in leadership at the CFPB? I think we saw under former Director Kraninger that sometimes a Republican appointed director can surprise you and actually be very active. Former Director Kraninger was very active in enforcement, and was filing lawsuits that had like Townstone had a very aggressive legal theories that were suspect. The Townstone case not only had the statutory authority impairments that I mentioned, but also had very, very significant First Amendment implications, and that was filed by former Director Kraninger. So that was unexpected. Plus, former Director Kraninger had other investigations which are non-public that also had aggressive legal theories. So there are things that the public doesn't even know about that was happening behind the scenes, or things that came up in exams which are non-public. So, but what we do have is a high frequency, high number of public enforcement actions by Director Kraninger. So just because there's a Republican appointed director doesn't mean the CFPB is going to be asleep at the wheel. She had the CFPB going at a pretty aggressive pace enforcement wise. On the rulemaking front, she did roll back some of the Cordray era rules, like the payday rule, but only to a certain extent. She kept some provisions of the payday rule in place, so there wasn't as much rolling back of rules and enforcement as folks would have suspected or expected, I should say. So I don't think that the CFPB is suddenly going to go dark if we have a change in administration. I think some of the aggressive rulemakings, if on the docket, if they haven't been finalized by the time the agency's leadership changes, those will probably die on the vine. We won't see their final rules come out. Maybe withdrawal of those proposals, or if there hasn't been a proposal yet, that project will just go away. For example, in mortgage world, the CFPB is reported to be looking at a ban on mortgage lenders from charging borrowers for the lender's title insurance policies. That was reported in publications a few months ago. And then we had a request for information come out from the CFPB looking at mortgage closing costs, and essentially saying that a lot of mortgage closing costs were junk fees, and the CFPB is going to be looking at them. And it kind of, you can read the tea leaves there. The CFPB is looking at them from a UDOT perspective, which I think means that they're probably working on a proposed rule. I don't think if you have a Republican appointed director that something like that would see the light of day. That's just very aggressive. This whole junk fee warpath that the CFPB has been on, I think probably wouldn't survive a change in administration. But it doesn't mean that the CFPB is going to go dark.
After an hour, I don't know if we have more clarity, less clarity, or we just have a lot of information that's out there that everyone's like, wow, okay, now what do we do? This is where having a good attorney representing you is definitely helpful in this industry, because you're going to need it. That's why the three of you are here. And if anybody who's watching this wants anyone's direct contact, please let us know, and we will certainly forward you their information. They're easy to find as well through their firms to do that. So I'm going to throw this around one more time for final words and thoughts from everybody. So what are you guys' final thoughts on Chevron and the direction we're going to? And is this, like I said, more muddied waters, or is this clarity that, hey, I can see the end in sight, but, the reality is there's never an end in sight. So, something's always coming up.
It's certainly not clarity, in my opinion. And I think, as was previously, I think Richard pointed it out, maybe it was you, Joann, my apologies, one of you making the point about whoever's in power at the federal agency, states that are on the other side of the spectrum pushing back. We're already seeing that. It really started, I think, under the last or two changes in leadership ago at the Bureau, when we went from Director Cordray to Director Kraninger, in the consumer space, at least, which is all I'm speaking to. We really saw states take up the banner and start being more aggressive in the laws they pass, how they're enforced, the positions they're taking. I didn't think they'd be able to keep it up. They did. They're very integrated. To your point, Richard, Director Kraninger actually did a lot of things. It was maybe in a slightly different juxtaposition versus the industry. But I tell people, everything you have now with the inadvertent repossession standards has its genesis in the 2018-19 timeframe under Director Kraninger. So maybe the states didn't need to assume they had to get that aggressive, but they did. It's worked. It also aligns with other places we've seen the jurisprudence of this particular Supreme Court about trying to have more room for federalism at the state level. And I think we're going to see a lot of that.
Yeah. So, I think the Supreme Court's these decisions may roll back regulation, but they don't roll back regulators. All these agencies are still there, to Richard's point. They are not going to go dark, and they have jobs to do. And so there wasn't, and the Supreme, it's going to be, a president can't come in and just wipe out an agency. There's appropriations, there's, these are institutions that they may look different, but the skeleton and the structure are there, and the people that work there are still there, and they have jobs to do. And what we saw, to everybody's point, when Kathy Kraninger came in, I think as a true bureaucrat, she realized and supported the departments that she had, and she supported enforcement, whether you agree that these actions were appropriate, but there was a lot more so ever, I think, in the Cordray era. So these people have jobs to do, and they're going to continue to do those jobs. So I say to, industry folk, and all of us have been on various webinars and talked to people and written articles. This isn't, it's not a get out of jail free card at all. This is, you've got to continue to be compliant, do the best practices that you can, work with the statutes that you know and understand, and how you think they are interpreted based on the law, and dealing with whether it's your in-house general counsel or your outside counsel, to follow the law to the way it should be. And that needs to be done probably now more than ever, because if it's going to be challenged, you want to say, hey, I looked at the statute, and this is how it's consistently has been done, and this is how I'm going to continue to do it. So I urge that to industry to stay the course as best as possible, and to think critically before challenges. You want to go down that road of challenging an agency.
Yeah,
Richard, you get final words. So here we go.
The Stefanie and Joann, it was been a pleasure presenting with you, and you raised great points in your final words. I don't know if I have anything to add. I'll just reiterate that the agencies are not going to go away. That's a great point. There's still going to be rules. They're going to expect you to follow them. You're still going to get examined. There could still be issues that come up in exam, and there's very technical rules that you have to follow that aren't going to go away, or even you're not going to have the ability to challenge them because Chevron deference went away. If the statute says you have to provide a disclosure within 3 days of application, that's something that's going to have to be done. And so there's still compliance work to be done. Now, like I said before, Chevron going away could increase the likelihood of success if you were to challenge an agency action, either a rule or enforcement action, but it's not a reason to take the foot off the gas for your compliance work. So stay compliant, keep working at it, and don't expect the agencies to just suddenly go dark.
All right. With that, we are concluding the Credit and Collection News podcast for today. I want to personally thank Stefanie and Joann and Richard for taking an hour to talk about Chevron and talk about the industry, because this is the most important time right now for the industry to understand what's going on, to what's happening. There are so many changes. And if you have any other questions or any other concepts or ideas that you want to ask, please do. Send the information into Credit and Collection News, and I will forward it on to the person that you want to answer your question. And maybe they will respond without an agreement for service. So they'll give you a little bit of free advice, but always make sure that you've got yourself a good lawyer and a good attorney firm to represent you, because there is nothing but change coming out there, and we'll do that. Thanks again for watching. We enjoyed it, and look forward to the next one coming up. Thanks again to everybody, and thanks again for reading Credit and Collection News.